Thank you, everyone, for joining us for this episode of the Immigration ABCs podcast. I'm your host, Dustin Saldarriaga, an immigration lawyer with Scott Legal PC in New York City. Today, we are speaking with my colleague and the managing partner of Scott Legal PC, Kelly LeGrand Weiner, about how the F1 student visa can be an excellent launchpad to start a career as an entrepreneur in the U.S. This is a topic that I really like because there are so many people in the US who are on an F1 visa and who are early on in their careers. And the sense that I get is that very few of them are aware of the many possibilities available to them while they're on an F1 visa if they're looking to pursue entrepreneurship. Kelly is especially well suited to discuss this topic. She's been with Scott Legal almost since the firm's founding. She joined in 2014. And in that time, she's helped clients navigate a large variety of visa options. Including, of course, the F1. She's a graduate of both New York University and New York Law School. And before joining Scott Legal, she volunteered with the Safe Passage Project, where she represented undocumented children applying for asylum and special immigrant juvenile status in the United States. So, Kelly, to get us started, first of all, thank you for being with us. Can you share a little bit about what it is about immigration law that attracted you to this career path?
Thank you, Dustin, and very happy to be here. So I always had an interest in different cultures. I was an anthropology major in my undergraduate. And, when I went into law school, I kind of started to do work on the family law side. And upon graduating, had the opportunity to volunteer with Safe Passages, assisting children with special immigrant juvenile status petitions, which involves a family court component and an immigration component. So that was my first introduction to immigration, and I really enjoyed it. And from there, my interest in immigration grew. When I joined Scott Legal, I really had the opportunity to work on a wide variety of immigration matters, including business and family. And I found a really particular passion for working with entrepreneurs and helping people realize their dreams of starting a business in the U.S. And I've really enjoyed doing that, for the past 10 years.
Perfect. And I'm sure that the F1 visa has played a significant part of that. So we're not going to assume any real deep knowledge of the F1 visa in this episode. So why don't we start from the basics? Why don't you share with us who the F1 visa is intended for?
Sure. So the F1 is a student visa. It's primarily intended for people attending U.S. universities and post-secondary programs. It can also be used for studying a language, like English language courses and liberal arts. And on a very limited basis, it can be used for children to attend private elementary or middle schools and public or private high schools.
And how do you qualify for an F1 visa? What are the basic requirements?
So to qualify, you have to be enrolled full-time in an academic educational program or a language training program. You have to be enrolled in a school that is approved by the Student and Exchange Visitors Program, which is run by Immigration and Customs Enforcement. You also have to be proficient in English or enrolled in courses to become proficient in English. You have to prove you have sufficient funds to support yourself during the entire period of study. And you also have to prove that you are maintaining a residence abroad, that you don't have any intent to abandon. So you have to prove you don't have immigrant intent.
Great. And in taking a look at the application process, what does that process look like in terms of the role of, you mentioned ICE, the role of the consulate, the role of USCIS? What does that look like?
Sure. So the first step is obviously you have to apply and be accepted to the school. Once you're accepted, you'll register with the Student Exchange Visitor Information System, also called SEVIS, and then you'll pay a fee. It's using Form I-901. After you're registered, the school is going to issue the student a Form I-20. This is a very important document and really the main document that the student needs. Once they have this form, then they can submit an application to a U.S. consulate in the country where they live. If they're already in the United States, they could apply for a change of status, or if they're Canadian and visa exempt, they can take the I-20, and the proof of the, that they have the available funds and the non-immigrant intent, and go to the border and get an F1 stamp directly from a Customs and Border Protection officer.
Great. And since the focus of our discussion today is how to use the F1 as a springboard to becoming an entrepreneur, one of the clear ways that you can use an F1 is if that's your academic program, I assume. Is that right?
Yes, absolutely.
So you can take courses on entrepreneurship, but let's I know we want to discuss other ways that you can use an F1 besides that very direct way. So if Kelly, someone schedules a consultation with you and says either I'm already in the US on an F1 or I'm going to be getting my F1 soon, and my goal over the next 5 years, 10 years is to run my own business. What options are you thinking about in that discussion?
Sure. So, one is the F1 student should really pick a program that's going to speak to what they ultimately want to do, because any work authorization you're going to get through your F1 visa has to be tied to your program of study. So it's not a good idea to study in a field that's completely unrelated to the company you want to start. You want to make sure that there is some nexus there between the field of study and the company you're interested in starting. And then in terms of options, there are many work authorization options available for F1 students, but they're all very heavily regulated and meant for different things. So options I think about are CPT, curricular practical training, OPT, optional practical training, STEM OPT, and also thinking about once the F1 program is done, changing status or applying for a work visa at a consulate, for example, an E2, a TN, an H1B, an O, things like that.
And throughout all of these options, and really from before you get the F1, when you're completing the I-20 that you mentioned, there is a very important person throughout this process called the designated school official, or the DSO. And when a lot of people think of kind of the role of the government in an F1, they think about USCIS, about ICE, but the F1's interesting in that there is this DSO, or designated school official, who actually has a lot of power over the scope of what someone on an F1 visa can do. So can you tell us what is the role of the DSO and why that person's so important?
Sure. So the DSO is the student's main point of contact for making sure all their records are properly updated and maintained in the CVIS system. DSOs also help students avoid problems. They advise them on how to follow procedures. For example, if a student wants to reduce their workload, change their major, transfer to a new school, if they want to work in the US, all of these have to be discussed and reported to the DSO in a timely manner. And they want to make sure they're working with the DSO to ensure that their CVIS record is always properly updated.
Great. And one other point that before we start diving into the options that you mentioned before, that I think is really important to touch on, because, well, I'll just say it. It's unauthorized work. And anyone in the U.S. Who's visiting should be careful that they not work without authorization, because that's something that can stay with them. It's something that can have an impact if they apply for a visa in the future or apply for any immigration benefit in the future. So we want our listeners to be very careful that even though we are talking about options to work on an F1, it is important to always make sure you have work authorization before you do that work, regardless of what we're talking about, whether it's curricular, practical training, OPT, whatever it is. Kelly, do you have how do you think about when you're talking with someone on an F1? How do you frame that? How do you frame that risk? And what are the broad strokes of what you think someone should keep in mind just to make sure they don't violate that prohibition on unauthorized work?
So unauthorized work, I'd say, it's not defined anywhere specifically. Very often people will ask about, can I volunteer? If they don't pay me, is it okay? I think for students in particular, an important thing to remember is these programs that are, that are administered by ICE are extremely regulation heavy, and there's a lot of room for error, accidental error, but ultimately the student is the one that suffers for that. And so you really want to keep an open line of dialogue with your designated school official. And anytime you're doing anything that is remotely related to work, even if it is, for example, working for a professor that's brought you in, on and is going to pay you. All of those things need to be discussed with the DSO in advance. I think that's very key. Making sure that you're discussing it with them before you start any work.
Absolutely. So, with that being said, let's go ahead and turn to the options that you mentioned before for how someone on an F1 visa can actually start to get some experience and start to build this path toward being an entrepreneur. One of the first things you mentioned is curricular practical training, or CPT. Can you tell us what is CPT and what exactly does it allow the student to do?
CPT stands for Curricular Practical Training, as you mentioned, and it's meant for students to be able to work in an area that's integral to their major. The CPT experience has to be part of the program of study, and it's really meant for things like required internships or practicums that are part of a degree program. So that was really the idea behind it. It's not meant to be full-time employment long-term, although it can be used for full-time employment during a program. But again, it must tie back to an academic component of the program. And it can be part-time, it can be full-time, but it is important to note that if you use 12 months or more of full-time CPT, you will lose an opportunity to be eligible for OPT, which I know we'll discuss later.
Absolutely. And so if we are specifically thinking about someone who wants to go into entrepreneurship, to have their own business, what are some ways that they might use CPT toward that path?
Students can use CPT strategically to gain relevant experience that's going to help them with the business they plan to run. I think it's also a great way to make connections in a relevant industry, get familiar with employers that may eventually be your clients. Or maybe your mentors. One thing to note is that CPT does not allow self-employment. So the student could not use CPT to run their own business while they're in school.
And with that, let's switch over to OPT. So OPT tends to be the most common way, at least that I've seen, that that someone who is in F1 status will begin to take significant steps toward entrepreneurship. So why don't we quickly start with what is OPT and why is OPT oftentimes a critical opportunity for F1 visa holders who want to gain experience or start a business in the US?
OPT stands for Optional Practical Training, and it allows students to apply for up to 12 months of work authorization in their area of study. It can be used before your degree is finished, and this is called pre-completion OPT, or it can be used after the student has graduated, called post-completion OPT. So OPT provides this chance for students to build their skill sets with an employer in their field, but it can also be utilized for the student to start their own company. So it is different from CPT in that way. Utilizing OPT is a common way students build relationships with employers who might be willing to sponsor them for work visas. Additionally, if a student wants to start getting traction for their own company in the US, OPT will provide that opportunity, 12 months to be able to develop the company, try to get things set up, try to get things running, as long as, again, the work has to be related to the program of study.
And the majority of people who are using OPT are using it to work for someone else. They're working for a business in the US rather than being self-employed. And I think a lot of people who learn that they can use OPT for self-employment are surprised by that. So are there certain things that someone who does want to use OPT for self-employment that they should keep in mind, or certain challenges that they might face when speaking with their DSO or when getting approval to be self-employed on OPT?
So deadlines for OPT applications are very strict. You want to work with your DSO to ensure your work authorization application is timely filed. And prior to that, you will need to show your DSO that you have a proper business license and that you are going to be working on a company that relates to your area of study.
Perfect. And so that nexus, making sure that the entrepreneurial venture is connected, is related to the field of study is again an important aspect of it. In recent years, the U.S. government has actually taken several initiatives to really encourage people who have backgrounds in STEM subjects, and STEM meaning science, technology, engineering, or math. And one of the areas where they've kind of tried to encourage people and support people in STEM subjects is through OPT by offering STEM OPT. So could you tell us a little bit about what STEM OPT is and how STEM OPT is different from standard OPT?
STEM OPT allows for a 24-month extension of work authorization. So this is great. It's an additional 2 years beyond what you can get on OPT. The extension has to be filed in the 90-day period before the OPT employment authorization ends. Again, deadlines are very, very strict. The regulations do not provide wiggle room here. I think, it comes up a lot that students will say, well, I was close. I was only 1 day late. Unfortunately, the government is not forgiving in these types of situations. So you do, again, need to make sure that you're following the deadlines. Employers who hire students on STEM OPT have several additional requirements and responsibilities. So for example, they have to be enrolled with E-Verify. They have to complete a training plan called Form I-983 that explains how the company is going to train and oversee students during the work period. There also has to be a bona fide employer-employee relationship between the company and the student, and the company has to show they have sufficient resources to train the student. DHS can even conduct site visits for STEM OPT employers. So it's, again, very heavily regulated. And unfortunately, due to this requirement of an employer-employee relationship, self-employment is not permitted on STEM OPT in the same way it's permitted on OPT. So if you've worked owning a company 100% on OPT, that is not going to work in STEM OPT. There would need to be changes made to the company, to the ownership structure, to the employment relationship to allow that to work in a STEM OPT scenario.
Really, really critical point. So, a fundamental difference if you're looking to pursue entrepreneurship, STEM OPT does not allow self-employment, whereas standard OPT does. Great point. Of course, you've said regarding both STEM and standard OPT, it's a temporary period. We're talking at max 3 years, right? If someone has STEM OPT, so obviously someone who is in this situation is looking to be an entrepreneur, is an OPT, and they want to be here for longer than a few years, they're going to need to look for other options. If someone reaches out to you, a prospective client, and they say, I'm in OPT now, I want to stay in the US after my OPT ends. What is your advice to them in terms of how they can position themselves to be successful as an entrepreneur as their OPT comes to a close?
I think they really do need to utilize that time they have on OPT to investigate their options and make a plan for when OPT ends. And that's going to include looking at the full spectrum of work visas that are available to them, thinking about their future. Do they plan to get a master's degree? Do they plan to get a PhD? What is their long-term goal? And then trying to align those goals with what work visas may be available. Because there are some entrepreneurs who may have gotten their bachelor's degree and done OPT, but maybe they want to pursue a master's. And so there may be additional work authorization available to them to help continue developing their company during that time. So sometimes continuing on the educational path is one option. And then obviously there's several work visas they could consider as well. And those are things you want to plan for early to make sure you're building in time to prepare those applications.
You mentioned a master's and a PhD, more advanced degrees. How does it work with OPT? Do the rules just restart and any past OPT doesn't influence future OPT? Let's say you've got your bachelor's, you studied economics, and let's say you're going to get your MBA. How does OPT work when you're on that master's degree?
Sure. So you're eligible for OPT at each level of educational, progress. So if you get a bachelor's degree in economics and then you got another, you're going for another bachelor's degree program, you're not going to have more OPT. But if you are doing a higher level program, you're going up to a master's or a PhD, you will be eligible for OPT at each of those levels.
Perfect. So you mentioned visa options. What in your mind, you've handled a very broad spectrum of visa options. We talked about how you've assisted people pursuing special immigrant juvenile status, asylum. You do business cases now. You've also handled family cases. So you've kind of seen the full spectrum of visa options. What do you see as the key visas that someone who wants to pursue entrepreneurship and is on an F1, maybe doing their OPT? What are the visas that you think, generally speaking, someone might want to consider?
So the E2 visa, I think, is an amazing visa for entrepreneurs. It's something that, if you are eligible for it, it is really perfect for entrepreneurs. It is completely set up to allow someone to come and develop and direct a business in the United States. That's its main purpose. And so I think it fits most neatly for entrepreneurs if it's available. If it's not available, and unfortunately the E2 visa is not available for Indian nationals, Chinese nationals, there are some other options to consider. So for example, the H-1B visa for entrepreneurs. It is quite tricky, and that's something that we can discuss in more detail. The O1 visa also comes to mind. This is specifically comes to mind for people who perhaps are farther advanced in their career and maybe came to the United States after working for several years, perhaps to get a master's or a more advanced degree, or to go into a different field. That may be something to consider if you have a background in working already.
Perfect. And each of those options that you mentioned, we will talk about each in more detail. The E2, the H-1B, the O-1 all allow self-employment. They may require some specific aspects of the application to be deliberately crafted to make it clear that they are eligible in spite of the business being owned by the applicant. But I want to quickly contrast that with the TN visa, because many people who are nationals of Canada or Mexico are familiar with the TN, which is a wonderful option to work in the US, but is not a wonderful option if you want to own the business in the US. So one of the visa options you mentioned is the E2, and you mentioned that if you are eligible for the E2. So could you tell us a little bit about who is eligible for an E2, what are the requirements and the benefits of an E2, especially for someone who wants to pursue entrepreneurship?
Sure. So the E2 is available for nationals of countries that have a specific treaty with the United States. There's a list of these countries. They're really from all over, Europe, Africa, Asia. There's many, many countries that have these treaties with the United States. Portugal just signed a new treaty, so it is also possible that countries, are not E2 treaty countries and become treaty countries. There's also some where the treaties have lapsed, Iran, for example. So if you are a national of a country that has this E2 treaty with the United States, you can apply for the E2 visa. The requirements, besides being a national of a treaty country, are that you need to own at least 50% of the business. You need to make a substantial investment, and there is no dollar figure. I think a lot of times people confuse E2 and EB5. They think I can't get an E2 because I have to invest $1 million. That's absolutely not the case. The E2 treaty investor visa, the substantial investment piece really depends on what type of business you're starting. We've had investments approved even as low as $30,000. That's a very risky case. That's a very difficult kind of case, but it is possible. So you're going to make that substantial investment. That is going to depend on the type of business you're starting. It has to be the investor's personal funds. They have to be committed and at risk. So that means If you're starting up a brand new company, that means you need to kind of pay for the things you need to start your company: your website, your computer, your registration, your licenses, your insurance, your marketing, things like that. If any specialty equipment is needed, that needs to be purchased. You can also purchase a business outright to get the E2 visa. That's another option. Additionally, the business needs to hire workers in the United States. You can't just be a solo consultant. And you need to be actually developing and directing the business. So it's not for someone who just wants to be a passive owner. They need to be involved. And finally, the business has to be real and operating. So this means if the business is already running, you're going to show things like tax returns, invoices, licenses. If it's a startup, you'll show things like lease agreements, client contracts from prospective clients. And once the E2 visa is granted, it does give you this ability to, run this company in the United States long term, as long as you are continuing to hold at least 50% ownership within the, within the company, and it continues to meet the E2 requirements of, taking in revenue, hiring employees, and doing business in the area that you've represented to the U.S.
Great. So the E2 is explicitly, I should say the E2 investor visa is explicitly intended to be for entrepreneurs. So a really great fit for those who are in the US on an F1 and who are eligible. And I'll just say, when someone comes to our firm and they are from an E2 treaty country and they're looking to start a business, Kelly, would you agree that the E2 is going to be probably the first thing we consider, because it is just such a great visa option for entrepreneurs?
Absolutely. And I think one thing for F1s just to remember as well is the source of the money can be a gift, right? So many students may not have much money yet. Gifts, personal loans that aren't secured on assets of the business, all can be used to fund the E2 company.
Excellent point. Excellent point. And Kelly mentioned that we have had cases with very low investment amounts. One of my favorite examples to share is our own firm, which Ian founded on an E2 visa. And is obviously a service firm, which does not require a large investment. So we will have another episode in the future where we really go into more detail on the E2. So do keep a lookout for that episode. Let's switch. You mentioned the H-1B. I know the H-1B is also sometimes used by entrepreneurs, though not nearly as often as to work for a US-based employer. Can you quickly tell us a little bit about the H-1B, what the requirements are, kind of the application process, and if you want to apply for one as an entrepreneur, how does that application look different?
Sure. So the H-1B visa, is a visa that's available to people who have a job offer from a U.S. employer where the job requires a bachelor's degree and the applicant has that degree. So there does need to be a nexus between kind of the job that's offered and the degree that the person has. That's basically, those are the main requirements. And the H-1B was really envisioned as a way for F1 students who are, starting up in their careers, don't have experience yet, can be hired just on the basis of the job requiring a degree and them having that degree. Ultimately, one of the challenges of the H-1B is that there's a lottery, and there's a lottery because there's only 85,000 H-1Bs available each year. And there's many, many applicants, hundreds of thousands of applicants that are kind of vying for these slots each year. So that is one significant challenge of the H-1B, is just there aren't that many of them. Then if you're talking about trying to get an H-1B for an entrepreneur, there's additional challenges. So the H-1B does require that there is a bona fide employer-employee relationship. That means that the employee must, be able to be removed from the position. So if you are a 100% owner of a company, you're really not going to be able to easily convince the government that you're going to remove yourself from this employee role. What that means is that if you're trying to use the H-1B as an entrepreneur, obviously you better to have other owners, better that you don't own, 100%. Additionally, you would want to have a board of directors. So even let's say you own 60%, that's still potentially a concern. If you have a board of directors that have the ability to remove you as an employee, that can be very helpful in showing that this bona fide employer-employee relationship exists. Another challenge for startups is that H-1Bs are regulation heavy and do require that the employer pay a specific wage called the prevailing wage to the employee. And they have to, sign many documents explaining, attesting that they will pay this wage. They have the ability to pay this wage. So sometimes if it's a brand new company, that's, going to be obvious on the forms. The government may come back and say, how are you funding this? Will you be able to pay the wage? If you have a business bank account with $0 in it, will you actually be paying this prevailing wage? So that's something as well to be concerned about. Sometimes, even if a company is pre-revenue, but if they have some kind of, VC funding or other startup funding available, that can be utilized to address these concerns. Another thing is there enough specialty occupation work available? And when I say specialty occupation, what I mean is work that requires the bachelor's degree that the person has. So again, there needs to be that nexus between what is the person doing, what is the actual job and what is their degree? And do you have enough work, even in a startup scenario, for the amount of time you're asking for on the H-1B?
Great. So it's pretty clear that comparing the H-1B to the E-2, the H-1B does require some jumping through hoops, being very deliberate and careful about how the application is framed for an entrepreneur, whereas the E-2 is kind of custom tailored for entrepreneurs. But I think the one of the key takeaways from the H-1B is that for those listeners who do not have a passport from an E-2 treaty country, I have China, I have India in mind, Brazil, South Africa, there is a visa option to pursue your own venture in the US. The H-1B is one of those options. And another option is the O-1. So Kelly, could you tell us more about the O-1? Who is the O-1 a good fit for, and what are the basic requirements for the O-1?
So the O-1 is meant for individuals of extraordinary ability in the sciences, arts, education, business, or athletics. There's two categories. So the O-1A, which is extraordinary ability in science, education, business, or athletics, and then the O-1B, which is for the arts and the motion picture and television industry. The O-1, because it requires a showing of extraordinary ability, so it's really appropriate for people who can show that they have reached the very top of their field and can show sustained national or international acclaim. In the student context, this is really not going to be very workable, usually for someone who has never held a job and went straight from high school, into college. However, there's many people who come to the United States and study later on in life. Perhaps they, worked for many years and now they're coming to get a master's degree at a US university or something like that. So it's always good to look at the person's background and see, is there this evidence of extraordinary ability? Have you won prizes and awards? Are you a member of associations that require outstanding achievements in your field? Have you made any original scholarly contributions to your field? Has there been media published about you in kind of major publications, either, popular press or completely relevant to your field? So generally the way you qualify is you show you meet at least 3 out of 10 criteria. Either, and there's separate categories for O-1A and O-1B. But again, this is generally going to be used for people who already have had a career and have built up that extraordinary ability and are now in the United States in F1, perhaps just getting a different degree. It's really not going to work for someone who has only ever, for example, won student awards. Those are generally discounted. So if you're really just starting off in your career, the O-1 is not an option. But if it's somebody who has already achieved a level of success in their career that's substantial, it could be something to consider.
Absolutely. And given what you shared, which I completely agree with, I will just say it's never too early to start taking the steps that may qualify you for an O-1. So if you are a student, those connections that you have with professors may be the pathway you have to start publishing, to start judging others' work if you get plugged in with Y Combinator as a student, for example. So the university kind of ecosystem, I think, is very helpful for channeling people into those contacts that over time will give you the credentials to apply for an O1. So all of the options we've talked about so far, the O1, the H1B, the E2, these are non-immigrant visas. So these are not green cards. Part of the requirement for each of these is that you technically cannot intend to stay in the U.S. permanently on any of these. Now, granted, there is something called dual intent. So, for example, for an H-1B, it is okay to apply for a green card, but the real point I'm trying to make is that these are not green cards themselves. So, Kelly, why don't we talk about the green card options? If there's someone who is in the U.S. on an F1 visa and they say, you know what, I would love for my venture, my entrepreneurial venture, to support me in a green card application. I really want to stay in the U.S. permanently. What would be your guidance for them in general, and what green card options, assuming they don't have family options, which of course feel free to talk about if you'd like, but what employment-based options would be on your mind for them?
Sure. So, two that come to mind are the EB1A and the EB2 National Interest Waiver. And the reason why these are really the main ones to be used by entrepreneurs is that this allows you to self-petition. One of the challenges for entrepreneurs in the what I will call the most common process by which you get a green card through employment, which is a U.S. company will sponsor you for a green card through what we call the PERM process. That is not available to entrepreneurs for reasons that I won't go into in detail here. But so ultimately, what you need to do as an entrepreneur is, look at the EB1A or the EB2 National Interest Waiver. The EB1A looks very much like the Extraordinary Ability O1 visa we just talked about, just with a heightened standard. So again, must show sustained national or international acclaim in your field, must show that you meet, several of these, at least three, but ideally more of the requirements, on the list for showing extraordinary ability. So this is, again, going to be for somebody who has already had a developed work history, can already show that they themselves are extraordinary. The EB2 National Interest Waiver can sometimes be a more attractive option for someone who's earlier in their career, because while it's important that you have the applicant themselves and their history is important, the real focus of the EB2 National Interest Waiver is on what the endeavor the person is doing in the United States. So to back up a little bit and just describe the EB2 National Interest Waiver in a little more detail, the EB2 category requires that somebody have either a master's degree or higher, or exceptional ability in their field. That's the threshold requirement for an EB2. And then for the National Interest Waiver, they have to show they're engaging in an endeavor that has substantial merit and national importance, that they themselves are well positioned to advance that endeavor, and that on balance, it's beneficial to the United States to waive the normal requirements of the job offer and labor certification process. So in this scenario, if somebody has during their F1 status developed, a company that's gotten a lot of traction from, outside investors, where, joined an accelerator that's very, high ranked, has had, private, or public actors weigh in on why this is so important. The strength of the endeavor and the fact that the applicant has been the one driving it forward, that can be something that can be utilized, for the green card, even if the applicant is not as experienced in their field. So for the EB1A, the green card option, you really do need to have someone, the focus is on the individual. They themselves have to be extremely advanced within their field. For the EB2 National Interest Waiver, it obviously strengthens the petition the more experience the person has. But if they are working on this venture and they have gotten it to this point where, there's outside interest from investors, from government actors, from, private industry, all of those things can be utilized, to help demonstrate why an EB2 National Interest Waiver, would be a good option. One thing to keep in mind, though, is that for the EB2 National Interest Waiver, showing that a business has substantial merit and national importance, it needs to go above and beyond just, I'm going to run my business really well and do a really good job for my clients. I think we do get a lot of people that come in and ask about this option, and they say, well, my business is doing really well and our clients love us. It does have to go above and beyond that. There does have to be a tie-in to what is the substantial merit of what you're doing, and then what is the national importance to the United States. So one example is, if you're running your business in an area with really high unemployment, and you can show through an economist report that your business is going to hire many, many people in this area, there's going to be revitalization. Those types of things can be very helpful for entrepreneurs when they're looking at the EB2 National Interest Waiver.
Wonderful. And I will quickly add that we do have a separate episode recorded with Jie Huang, who is our colleague with extensive experience preparing national interest waiver applications. So if you're interested in that option, do check out that episode. So Kelly, I think that wraps up the main non-immigrant visa and immigrant visa or green card options. So we will go ahead and begin wrapping up this wonderful episode, very informative episode. Before closing out, you have a lot of experience working with many clients. You've seen the process through many people's eyes. What is one takeaway you'd like to leave our listeners with, whether a piece of advice or encouragement or an insight?
I would say think long term. Really think about what it is you want to accomplish in your career. And even though when you're at the beginning of your program, you may not be focused on that, really at a certain point, maybe when you're 2 years in, 3 years in, start to give some thought to what do I want to do? And if what you want to do is stay in the United States, start to work on that now. Start to think about, do I want to join an employer? Do I want to start my own business? What are my options? I think the thing that is always the worst is when someone comes to us and perhaps if they had started earlier, they would have had so many options available to them. But because they've come, I didn't file my OPT employment authorization in time. I think those things are always really sad to see because there are so many great options, but you do have to plan early. So really that would be my biggest advice is start to think early on in the process about what your long-term goals are, and then take steps to investigate and research what those are. Have a consultation with an attorney to figure out, what should I be working towards? What would be advantageous for me? I think that the long-term planning is really key to getting you where you want to go.
Wonderful advice. Kelly, thank you for joining us. Thank you for taking the time to share your experience and guidance. To our listeners, thank you all for listening. Please do subscribe, leave a review, share this with anyone who might be thinking about building a business in the United States. Stay well. We hope you'll join us for future episodes. And in the meantime, have a great day.